Is it the same?
Sounds like a pig. Yeah, yeah. Where are they?
They go, it's not far from San Francisco. And Howard, they have friends that are there every year. A lot of people. Yeah, they're not, they make the trip and
Yeah, I know, it's like, I passed the site, I know exactly where it's at. Is that right at afterwards, there's a string of hills. Yeah, so the trick, so instead, is just take the summer, and that way the whole falls down. Walk from here on. Share it on Friday. I have to leave the meeting early because I have to go to the voluntary support. They're saying, will never be the same. Can I ask you a question? No. Because my it's
yesterday. It's like a family affair. Yesterday my sister, now my cousin-in-law. Just gonna bring the whole parade through. This is Anthony. I'm gonna let him tell you how he pronounces his last name.
Good effort. It's MHW.
I'm gonna let him tell himself all about you, but several of you know Anthony because he's your private attorney and has helped you with estate planning. I've known Anthony for years through family relationships, but that's not why he's here. He's here because he comes very highly regarded by the residents and have worked with him here in our area for elder affairs, legal considerations, and he's just extremely personable, very accessible, and I have a great deal of confidence that he's going to take you through some things to think about in these years of your life and take questions and answers maybe. I'm going to leave you to it then, okay?
Will there be a handout?
No, but what I could do is I could send you, if you give me your email address, I can send you out the PowerPoints that we have.
Yeah, we can.
I can send out the PowerPoint if you give me your email address.
You can send it to us, we'll take
So,
care of it.
not a problem at all.
Actually, we have it, I can bring some.
Yeah, perfect.
We'll have them available at concierge, I will email it.
Very good, thank you very much, Michelle, appreciate that. So my name is Anthony Minovich, and as you can tell, I'm a local boy. Actually, no, just like Jeffrey, I'm from England. I practiced as a solicitor in England for a number of years, in this field, in fact, in estate planning and trusted estates and elder law, but in England, elder law is called private client, so that was the area of practice. In England, I had done that for a number of years, and then I met my wife, and who is from this area of New York, and she came over to live with me in England for a number of years, and she's a nurse. And I carried on, and then I decided, I just felt the itch to try something different, to go somewhere else, and I said, hey, why don't we look to go to New York and see where we go with that? So I went back to law school, took the bar exam, and then opened up my own shop. So here I am, many years later. That was me in the space of 30 seconds. But people often ask me, why elder law, why issues of disability, why this kind of area? Because people find it, generally speaking, if you're in the field, it's known to be more of a drier area if you are a lawyer. And so, but the real reason is I can't do anything else in the area of law. I'm no criminal lawyer, I'm no corporate type of bod. I was brought up in a working class family, a disabled family. My parents were both profoundly deaf. My brother profoundly deaf. In fact, I was the only hearing person in my family. So from the get-go, I was always advocating for my parents, advocating for my family. And so it was always kind of ingrained into me that I needed to protect those who were underserved, let's just say. So here I am, and I decided this was the field I needed to go into many years ago because this is all I understood. And I think that possibly, I'd like to think, shines through in my representation of a client. So, the general gist of today's presentation is really restricted to what are known as advanced directives. Basically, making a decision ahead of time about your wishes concerning medical treatment, about financial planning, and the like. Advanced directives is really an umbrella term. The collection of documents in New York which comprise advanced directives include the healthcare proxy, the living will, and the power of attorney. Now, just by way of some housekeeping, I thought I'd take the opportunity. I did look at the Woodland Pond residence agreement and scrutinized that. And I had noticed that there was some language in the residence agreement that references a resident having to hand over the healthcare proxy power of attorney. So I'm assuming you've all got those in place. If not, then this is ideal, this particular presentation for you. But that was something I had noticed, and I thought, well, what I'd do is I'd bring it to your attention. So, the healthcare proxy. Now, what in essence a healthcare proxy is a document whereby you are saying, hey, I want you to be the person to make healthcare decisions on my behalf, okay? Healthcare decisions, nothing else. But you're appointing someone who you trust, could be a friend, could be a family member, but it's got to be someone that you trust, and that's really fundamental, because that person is the person who's going to be deciding what your healthcare needs are going to be when you can't make those decisions. New York has a statute which provides a healthcare proxy. Right here what you see is that very healthcare proxy. It's a very basic form, as you can see, but it's issued by the Department of Health. It just spells out who you are, who you wish to appoint, who you wish to have as your backup agent, as well as organ donation. And then, provided you sign, date, in the presence of two independent witnesses, independent, someone unrelated to you, has no interest in the outcome of the healthcare proxy, then you have yourself a legally valid healthcare proxy here in New York. So, some pointers about the healthcare proxy, which is tremendously important to know about. You are considered to be in control of your healthcare needs until you cannot make those decisions yourself. Okay? That is absolutely important and fundamental in healthcare proxy terms. The law wants you to make those decisions until you absolutely cannot make that decision. Now, just because someone has been appointed as a healthcare proxy under a proxy form doesn't mean that they are immediately able to make those decisions. You cannot be the person, well, you cannot have the capacity to understand making those decisions, whereupon your agent then takes over those responsibilities. Very important. Now, here's the thing I hear quite often about agents under healthcare proxies. The classic, I don't care what mum told you, I'm telling you this. The agent is just that. Someone who stands in the place of the person who's given the power. Okay, so if my mum appoints me to be healthcare agent, and my mum has expressly stated that she wishes to have a DNR, do not resuscitate, but I don't agree with that. I can't stand up and say, hey, I don't agree with what mum did there, so we're not going to do that, okay? That's not how this works. You listen to me. That's not correct. As agent, I stand in my mother's shoes. I have to expressly say, yes, that's what my mum wanted. She wanted to be a DNR. I'm the agent, and that's an important obligation. So, the healthcare proxy law gives the agent the authority to only make healthcare decisions. That doesn't extend to making decisions beyond healthcare. Okay, it's very limited in that respect. Now, it can be broader if you have other documents in place, which we'll come on to, the power of attorney. But the role of the healthcare agent is to make healthcare decisions. It does not extend to personal rights, such as, I'm the healthcare proxy, and you can't come and see my mum because I'm the healthcare proxy. Or you can't call my mum, or my mum can't call you. Those are personal rights which are not healthcare decisions. So it's important we understand for healthcare proxy purposes, it's limited strictly to healthcare decisions. Only one agent at any one time. This is something I've seen. I've seen a few healthcare proxy forms where I see two agents, or sometimes three. And it's understandable. You have maybe a mum or a father who wants to appoint all three children to be the people to make those decisions. But the law makes it very clear, no, you've got to choose just one person to be that decision maker. Why? Well, the law recognises that it's an incredible burden for medical practitioners who have to make a decision, a healthcare decision, to go to 3 or 4 different people, only for there to be 3 or 4 different opinions. Nothing gets done. You get people throwing abuse at each other at the end. And the doctor is then left thinking, well, what am I to do? So the law makes very clear, you have one healthcare agent, and that one healthcare agent is who the doctor will talk to and make decisions about what should be done. Now, That's not to say you can't include other people. In fact, you might want to think about including in your healthcare proxy language to the effect that I wish my agent to correspond or to communicate with his or her siblings in reaching a decision. However, I understand that my agent is the one who has the legal responsibility at the end of the day. So at least it lessens her feelings, let's just say. So HIPAA authorization is tremendously important in the healthcare proxy. I pointed out earlier on the healthcare proxy under statute, it doesn't have a HIPAA authorization paragraph, which is important because if you don't have such authorization, then your agent is extremely limited in what they can do to help you. We're talking about the ability to obtain medical information to reach a conclusion, a decision. Now, without HIPAA authorization, the healthcare agent is limited to healthcare decisions, but how do you make a good decision without medical information, without a medical history? That's why these HIPAA authorizations are essential when in a healthcare proxy. Now, typically you have this section here. I'm sorry about the legalese, but it is important to see this. It's the kind of thing that you need to see in a healthcare proxy. You're effectively consenting to the release of medical records to the agent. If you have this, something to this effect in your healthcare proxy, you're good to go. Just waiting a second. All right, so I coined this one the Woodland Pond Healthcare Proxy because I was looking through the agreement and I thought, oh, there's some pointers in here which I think would be quite helpful in a healthcare proxy if you're considering updating such a document. One of which is the ability to designate your own attending physician. That one I see listed in 3.1.5 of the care agreement. The second thing is if there's a dispute resolution, in other words, there's a dispute with a team, let's just say, you're wanting to have your agent handle any dispute on your behalf. Now that's section 4.1.1 of the care agreement. So just a couple of things you might want to think about in the healthcare proxy that I picked up on when looking at the agreement. So that really was the healthcare proxy. It's not a very complicated form. It can be crafted in a manner that suits you. What you need to know about the healthcare proxy though is without such a form, you're left with having to go to court to get a guardianship. And that can be quite horrific because that can be very expensive. You're talking about involving people and emotions generally play a part in a guardianship proceeding, which can easily be avoided by having a healthcare proxy in place. But in addition to the healthcare proxy, typically read side by side is the living will. And the living will is something which is a document whereby you're expressing your wishes in connection with, it might sound depressing, but it's important, end of life treatment. Okay, you're in a situation here where you cannot make those decisions, your condition is terminal, doctors have said, there's no chance of recovery. At that point, we're talking about making your life as comfortable as possible. Okay? So you're painting a picture as to what your wishes are in that situation. So you'll see the living will itself has a peculiar name. It's I'm routinely hearing people saying, oh, I have a living will, that means this gets dispersed on my death to this child and that gets dispersed. No. The living will is not a will, it's not a trust, it's your expression of wishes while you're alive. So that's something I see pop up quite a bit. Now, do living wills actually work? This does pose a problem because you can have someone who might have prepared a living will from 20 years ago. Is that relevant today? Questionable. So you do get yourself into a bit of a sticky situation with a living will that might be 20 years old, if maybe that's not what your wishes are today. So it's not necessarily always the case that a hospital or a medical facility will honour those wishes. And when that happens, then we go to courts. Okay, and the courts have been very sticky about whether or not a will the living will for that matter, is valid. They bear in mind, or they take into account the age of the living will, the circumstances surrounding the individual at the time a decision needs to be met, and the words on the living will itself. So really, as any good lawyer would say, it really does depend. And you can see it from both sides. But how the courts construe a living will, if there is an argument or if it needs to go to court, is that it needs to be clear and convincing. Okay, no ambiguity. Any ambiguity means you have an invalidated living will. So when drafting a living will, you have to be very careful because you have to make it clear and convincing what your wishes are. Any ambiguity will be struck down, and the living will ultimately is worth nothing. But if you have a living will, it's usually read side by side with the healthcare proxy. I mean, I have found that when people construct these living wills and they sign these living wills, they don't think of it more as legal documents. They kind of consider it more as guidance for their healthcare agent. It's what they want their healthcare agent to understand and recognize at a time that they can't express or convey those wishes themselves. So the living will and the healthcare proxy are read side by side. They kind of form the umbrella term of the healthcare directives. Unlike the healthcare proxy though, the living will is a creature of case law. In other words, you can't simply just go to statute and download a copy of a healthcare proxy form. The living will itself is a form which is created by a lawyer. Some would say for lawyers, but in any event, it's drafted in a manner which is supposed to convey your wishes in a clear and convincing manner. Okay, so end of life treatment and what your wishes are. That's what a living will is. So we have the living will, we have the healthcare proxy, and now we have the durable power of attorney, which is very similar to a healthcare proxy in that you are appointing somebody else to make decisions on your behalf. However, unlike with a healthcare proxy where you are talking about healthcare decision making, this is one where we're talking about appointing an agent to make financial decisions. And in my practice, the power of attorney has effectively over the years become the cornerstone of any asset protection plan that you can do. Without doubt, it's, to me, the most fundamental document you can possibly have in the face of making sure your assets are protected during your lifetime. You know, people talk about wills, or living trusts, and the like, but the reality is without a good, effective power of attorney, there might not be an estate left to leave anything under a will or a trust. The power of attorney is what you use during your lifetime. Now, you'll see here, this list here is the grant of authority. And this is the kind of power you give to your agent under a power of attorney. Real estate transactions, bonds, shares, banking transactions, estate transactions, etc., etc. It goes on, it's wide-ranging. There's even the catch-all towards the bottom, N. It says all other matters. I mean, that's pretty much the catch-all, right? So, but despite this list here, that doesn't necessarily mean that your agent has the ability to do absolutely everything, because it's gone to court and judges have said, why have you done what you've done here? And the agent will say, well, you see, Judge, if you look under N, all other matters, you'll see that I can do anything. And judges have obviously felt that, no, we need to curb this just a little bit. So with that, we have these powers of attorneys which have been drafted, and these powers of attorneys, they take into account those in addition to the listed grant of authority here. Now, these powers listed include the following, such as real estate transactions, to include all fixtures, articles, personalities such as chattels, furniture, that kind. Insurance transactions, the ability to create, fund, and revoke a trust. Very important, very important. And also, going back to the healthcare proxy and the HIPAA authorization, you include language to have access to and disclose medical records. and other personal information, why not have it in your power of attorney as well? As well as to reimburse your agent under a healthcare proxy. These are all designed to make sure that if you have your healthcare proxy and your healthcare directives in place, you also have the power of attorney which takes care of the financial aspects, and sometimes they interrelate the two. It's like a Venn diagram. You have the two circles, and you put the two circles together, and you have that circle in the middle. That's what we're trying to achieve here with these documents. Trying to achieve so that it covers all possible issues. So Woodland Pond power of attorney. Well, I again looked through the residence agreements. I can see there was some language there about having your agent provide notice to the community to credit meal credits. That's section 2.4.2 of the care agreement. But there are other things that you might want to consider, such as the endowment fund, which I got the opportunity to speak to Mr. Coulty last week about the endowment fund. It's the Woodland Pond Benefit Fund, and truly I thought it was a magnificent fund and can only benefit Woodland Pond and benefit yourselves. So I would make the recommendation that if you're going to establish a power of attorney, you would want to expressly state in the power of attorney the ability to gift for charitable causes, such as the Woodland Pond Benefit Fund. But also the ability for your agent to engage in Medicaid planning. Now, I know people generally don't like to think that Medicaid will be something they should think about, but the reality of the matter is it is extremely important for everybody to think about Medicaid, because as we know, nursing home costs, medical care are very expensive, and there are situations that need to be thought about which might require the restructuring of assets, especially when there is a refund that is due to you, such as if you look at the Woodland Pond Residence and Care Agreement, there is a section under 9.1 that talks about the possibility of a refund. So you need to think about any assets you come into, and if you do require Medicaid assistance, you need to make sure that you have language in your power of attorney that spells out that you can engage in the restructuring of those assets to include refunds that might be received. So, another thing, the ability for your agent to sign a Woodland Pond refund designation form. Now this one I'm a little bit, it's a bit grey for me unfortunately, because when I looked at the refund form, and I'm sure you're all familiar with, there is a form that you have to sign that spells out that if there is a refund that Woodland Pond will make, who is it they make that refund payment to? Now, the form, when I look at it, looks like it references just the individual, so I'm not entirely sure whether your agent has the authority to sign such a form, and that's maybe something I don't know if there's counsel for Woodland Pond one day, I can talk to them about it. But in any event, it wouldn't hurt to have it included in your power of attorney in case you are able to do that. And we'll come back to the refund form in a few minutes. So, now I mentioned to you that the healthcare proxy and the power of attorney are two forms which are similar in the sense that you can designate an agent to make decisions on your behalf. Unlike the healthcare proxy though, you can name more than one agent in a power of attorney. Okay, so the law doesn't really mind, hey look, we get it. Healthcare decisions is a matter of life and death. We need just the one person to make that decision. When it comes to finances, you know, it's not a matter of life and death most of the time for a lot of people. So the law says you can have 2, 3, 4 agents if necessary. I mean, the more you have though, the more awkward things become though, i.e. if there's differences in opinions, etc. Now, unlike a healthcare proxy, the other thing to consider is you can have your agent act pretty much immediately, with or without mental capacity. In other words, you can be fully capable of understanding what it is you're doing, and you're in complete control of everything. However, your agent has the authority to do maybe certain transactions. So take, for example, if you're going on vacation and you have a house that needs to get sold, you can appoint somebody else to stand in your stead, your agent, under a power of attorney to sell the house on your behalf. But then you can also have a power of attorney which is one which takes effect only upon mental incapacity. Now that's called a durable power of attorney. as in it continues to run after mental incapacity. The power of attorney, like the healthcare proxy form, is really a form which is extremely in need of careful drafting, because everybody is different, everybody has different needs. And so the job of a skilled elder law attorney would be to really identify what those needs are and to make sure that these forms are constructed in a manner which suits the client. There's no one size fits all. So, and often I do get people who feel uncomfortable about the idea of doing a power of attorney because you're effectively saying, hey, I want you to make those decisions for me. However, what if they go behind your back? You know, that's something, it's psychological. People feel like, okay, well, my kids would never do that, but I can't tell you how many times I've heard people say to me, that would never happen, and guess what? It does. So, it's what we would need to do in terms of trying to protect the power of attorney as best we possibly can, and protect you as best we possibly can. There are a couple of things you can think about. You can make the power of attorney a springing power of attorney. In other words, once you become mentally incapable, your power of attorney springs into action. Okay, that's what they call a springing power of attorney. Now, that is a helpful provision to include in your power of attorney if you feel uncomfortable about the idea of an agent acting where maybe they shouldn't be acting. However, I would say that there are problems with a springing power of attorney, and that is if you include a provision that says it springs into life upon mental incapacity, then what you are saying is the banks will basically say, well, how do I know that the individual has become mentally incapable? So what happens in that scenario is you have your agent who has to continuously prove to the bank that the principal, the person who created the power of attorney, has become quote-unquote mentally incapable. So it can be quite the hindrance. But there are ways around that, and that is you could have a power of attorney where you, the principal, sign the power of attorney and just hold off on having your agent sign the power of attorney. There's nothing in law that says the agent must sign within a certain time frame. Nothing. So that being the case, you don't have a valid power of attorney because the agent hasn't signed. That's okay. Ma'am, you have a question?
Who decides you're incapable? What kind of doctor or two doctors?
So,
That?
yeah, the question here is who decides if you're incapable? That is, your practitioner will decide who's or someone who you've seen a medical professional with in the past year. Yeah, that typically is, that's how we've handled it in the office in the past.
Within the last year.
Within the last year. So if the agent doesn't sign the power of attorney, you don't have a valid power of attorney, but because there's nothing in the law that says that the agent has to sign within a certain time frame, therefore follows that if you did become mentally incapable in 10 years' time and your agent signed the power of attorney at that time, you have now a valid power of attorney. Now that's the reason why the law keeps it quiet as to when your agent's to sign, because they recognise that people feel uncomfortable about giving an agent the right to act. But at the same time, the importance of having a power of attorney shouldn't be underestimated. So that's the alternative approach. But at the very least, if you're insistent that you have a principal and your son or your daughter or your agent sign the power of attorney just because you want to get it done, and people generally do, you need to have a provision included in your power of attorney which spells out that anything your agent does, firstly, has to be in your best interest, which is rule number 1 if you're an agent. And secondly, that anything they do must be in accordance with your own estate planning documents, what your wishes are. So they must bear that in mind when restructuring your assets. So I'd recommend for all powers of attorneys language to this effect. If anything, just to allay fears about your agent doing something they shouldn't be doing. So, question?
Go back, I want to make a read that.
Oh, sure. And I'll certainly be happy to send you, or Michelle will be happy to send you the PowerPoint so you can take a look at that.
I will. Sorry, I'm trying to.
Okay, so at the very least, you're going to include this provision. Now, let's just go back to the Woodland Pond refund form. I mentioned earlier on about whether or not you can have your agent under a power of attorney sign a refund form, and that's something I'd like to talk to maybe council at Woodland Pond at some point, because it'd be good to include a provision in the power of attorney spelling that out. But in case you haven't already filled one of these forms out, I would strongly encourage you to consider making sure you leave your refund either direct to named individuals or to a trust fund, maybe if you have a revocable trust already established or a revocable trust. Because if you simply say, I want to leave it to my estate, then you're inviting something called probate, which is a mechanism in New York designed to spend many years and pay more money to the court system. It can easily be remedied. Just either leave it direct to individuals or to your trust estate in case you have a revocable trust or an irrevocable trust. Ma'am, there's a question.
Yes, if this is on the Woodland Pond form, I would recommend that you ought to specifically say the Woodland Pond Benefit Fund. Give them that right on, since it's a Woodland Pond form.
Yeah, absolutely. Well, if you look at number 1 at the very top, it says first to the Woodland Pond Benefit Fund.
Okay,
Via
so
the,
it's there.
it's already there. Yeah, it's already there.
Beautiful.
It's right there. So.
It should also include the Woodland Pond Endowment.
Yes, correct. It should also include the Woodland Pond Endowment. I did notice that earlier today because there are 2 types of funds, I'm aware. The endowment fund is the other type of fund, which I think we should really talk to Michelle about that one and have her maybe go back to the drawing board on that front. But that one certainly, but yeah, so number 1, you can leave your refund to the Woodland Pond Benefit Fund. Otherwise, you can leave it to your estate, which I don't recommend, or to your trust estate of probate, or to specific individuals. Again, avoid probate.
Or other charitable causes?
Or other charitable causes, absolutely. Absolutely. So people ask me, how often should I update my advanced directives? You know, my healthcare proxies, my living wills, my powers of attorneys. It's really very hard to actually say when it should be done. I usually say, well, every 5 years, just revisit your situation. What's going on in your life? Touch base with me. Tell me what's going on in your life. Sit down, have a cup of tea or something. We'll talk. But rule of thumb, generally speaking, if you have an illness, you might want to start thinking about your documents. They might meet with your wishes. They might not, don't know, but at least you need to think about it. Maybe if you have a change of intent, maybe your daughter, who you wanted to appoint as your agent of the healthcare proxy, is now no longer, you're not on good terms with your daughter. It goes on. You know, family fallouts happen all the time. You have a change of intent, so you might want to update your documents. But in any event, regardless of if any of those events have happened, you should be considering every 5 or so years, all right, what's going on with me? Do I need to revisit my papers? Do I need to update my papers? So really, that's kind of the gamut of the advanced directives. And I found a pretty neat photo there with hands up. So any hands up? Oh, we have a few. Goodness me. Okay. So I saw one at the back here. I'll come to you there in a second, Jeffrey.
Let me take the mic around,
Oh.
the other mic.
Thank you.
You said for the healthcare proxy, you can only have 1 person. For the healthcare proxy and the power of attorney, is it possible to have backup people listed on that form? You know, this is the primary person, but if that person can't serve, then the next person or the next person.
Absolutely, yes. I failed to mention that. Thank you so much for pointing out. you can name backup people, so you can have an order of succession. In other words, if I have my son as my healthcare agent, and my son is unable to act, then I would like to appoint my daughter to act as the alternate agent. And the same applies to powers of attorneys. But remember, with the power of attorney, you can appoint more than one people, so you can appoint 3 or 4. Now, in addition to that, you can have it so that the 3 or 4 agents can act either together or independently. And sometimes people say, well, what's better? Well, again, it's a personal choice, but I think from a flexibility perspective, it's easier and better to have it so that they can act individually. Because what if one goes away on vacation and the decision needs to be there? So.
In the healthcare instructions, I mean, about HIPAA, I think that sometimes when you go to an institution, they have their own form and they ask you to fill that form. And if you didn't have yours available at the moment, and there may be differences.
Yeah, absolutely.
What do you do in those cases?
Yeah.
That's one the question. I have another question, maybe address this one first.
Okay, so that's an excellent question, and that is a sticky point. You see, I have written some years ago in the Elder Law and Special Needs Journal about my experiences of acting as a solicitor in England and in New York. And one of the things I spoke about was in England there is a central registry system for the power of attorney or for the healthcare proxy. So that there is a system in place whereby if there is a question, you would just go to court and you would have the information right there. That doesn't exist here in New York, and that's a big problem. And believe me when I say I try to push and try to encourage the community, the elder law community, to recognize that it's important we have some clarity. And the way to have clarity is to have a central registry system. But unfortunately, today it's still, we don't know. So the long and short to answer your question is there is no right or wrong, but if you have a healthcare proxy, you should always make sure that you hand out your healthcare proxy to all of your medical practitioners, your whatever medical institutions you work with or go to make sure that they have it on file. That's as good as I can get, I'm afraid.
And the other question, sorry, Jim. The other question is, if you have multiple agents, there may be situations where they don't agree on certain things. How do you resolve that, or how do you typically address it? By majority vote, you have to make sure that you have an odd number of people.
Yeah. And this is the skill of the attorney. When you come to meet with the attorneys, draft with the attorney, you will talk about, well, what is the relationship? Will there be butting of heads between the agents? But yeah, to answer your question, what you do in those scenarios, you would include a provision that says that if there's a disagreement between, if there are 3 agents, that majority will rule, or if you're concerned about one agent spending too much money, then you can cap it. You can say, I want my agent to spend no more than $15,000 for my benefit. You would just construct it, which is why the power of attorney is a really important document in terms of how you construct it. You can manipulate it any which way you want to. But what I would say is you've got to be careful with that, because if you go too far, it becomes something that becomes ambiguous. And if you're talking ambiguity, you're talking about going back to the courts. So we be careful with that. It's a fine line you walk. Jeffrey, I think, hold on.
Living will.
Living will.
I used to be a professor at Johns Hopkins, doing academic research in the emergency departments and the surgical and medical intensity care. So I saw some deaths, and I was just looking at emergency deaths. I don't think I once in that institution saw an attending, a fellow, or an intern saying, gee, that's it, we can't do anything else. That worries, and even when there's a bracelet on the dying patient's wrist. So I think there's a problem there.
Yeah.
We can do whatever we can, what you've suggested, to express our wishes, but in 5 minutes, it can go to the wind.
Yeah, and I mentioned earlier on, my wife, she's a nurse, and she's seen all that, and often these living wills, they just get put aside. But ultimately, I think what the living will is for is also to make sure that your agent under the healthcare proxy understands what your wishes are, because they're the ones whose feet are on the ground. They're the ones who are there dealing with these doctors. And if a doctor is doing something that they don't necessarily think is the right thing for their mother or father, then they can actually say something. The paper might just be floating around out there, no one will ever see it, but that person who is there will know. Which is why I think it's equally important to understand that these living wills aren't just about, hey look doctor, here you go, these are my wishes, but also my agent under the healthcare proxy knows, and that person is more likely to be present at the time a decision needs to be made than my paper. Yeah.
Where does, I'll use the word, our ordinary will come in? That's not mentioned.
Not the living will?
I know you're not going to spend the whole afternoon on that, but where does that enter in, and which of the 3 or 4 areas that you discussed does our ordinary will have more effect?
So where does the ordinary will, this is a presentation about advanced directives, which the umbrella term means living will, power of attorney, healthcare proxy. The will's about what happens on death, so you're not alive at this point, so it's completely separate. However, I will make a promise, if Michelle can hear me, of coming back to talk about the will, to talk about the revocable trust and everything else you want to talk about at that time. Or if you want to ask me any questions about it afterwards, we can talk.
No, I knew you weren't going to cover that today, but just where does it fit in? Under one of these 4 things, is it most power of attorney?
Yeah, well, the power of attorney is really probably the most akin to the will, because the power of attorney talks about your estate while you're alive. The will talks about your estate on death. So if you were going to ask me that question, I would say it would be your power of attorney, because like I said earlier on, if you don't have a good power of attorney, you don't have an estate for your will to leave anything to. You know? So, I don't know if that answers your question, but it's the power of attorney.
What is the relationship of this most form with the other forms you've talked about?
Sure. So the most form is, if you like to just wave it in the air, can anyone see it? It's kind of hard to see. It's that pink form that, but the most form is, I think it's the medical order of life-sustaining treatment, and it's designed by the state to make it so that you can express your wishes, and it's primarily used because people want to have one form which cuts right across the healthcare settings, from home to independent living to assisted living facility to a nursing home. That one form will be used right across the board, okay? So they're trying to make it so that your wishes are more consistent, because it goes back to what we're talking about, Jeffrey, about trying to make it so we know what your intent is.
But there's no central registry.
But there's no central registry, which is why you would be filing the MOLST form with wherever you are, maybe an assisted living facility or a skilled nursing facility. That MOLST form is what your doctor would have and be able to share it with all the other institutional settings. So it's really similar to a healthcare proxy, except that it's more designed to cut right across, transcend across all the healthcare settings, more so than what a healthcare proxy can do. But what that form is it's really not something where you are able to expressly state your wishes in great detail like you can with your healthcare proxy or with your living will. There's no perfect system here, we understand that. And I'm not here to advocate that it is a perfect system at all. However, it is as good as it's going to get at this moment in time. You should have the healthcare proxy, and you should have the living will. The MOLST form is really designed for your doctor to keep hold of, so that should something happen to you, the doctor can hand that information over to wherever you go. So it's all there. Your healthcare proxy, your living will, is a private document that belongs to you, which you typically would keep at home.
I moved here from another state, from California, and I had all the
things done there last year.
Okay.
Do they need to be updated to New York laws?
Well, so the question is do we have an out-of-state document? Is it valid here in New York? And the long and short of it is that there is a reciprocal agreement between all the states in New York. If you've signed something here in New York and you go somewhere else, then that state will honor whatever it was you signed here in New York if you're in that other state. The only time when there is a problem is if there is, and I'm having a hard time trying to figure out maybe an example, but if there is a law here in New York which conflicts with a law in whichever state you move to, and you're relying on that New York document in that other state, that provision, whatever that provision will be stricken, will be invalidated. Doesn't mean that your form is invalidated, it just means that one provision is invalidated. If that makes any sense. But you're good. Any other questions? Oh?
I'd just like to say that, wait, no.
A doctor told me that these forms should be in the glove compartment of your car.
Yeah.
My car is in California.
Well, when you get one. I myself had a sort of a bad accident, but nothing happened. I mean, nothing happened at all for me. The car got there, but I had everything which has to be updated, I know, more than 5 years old, but it was in the glove compartment of the car. And I have some on my refrigerator, so make a copy of everything and put it in numerous places, and maybe that will help with what Yakov said, that if something happened in the car and you ended up in the hospital, those forms are there.
Maybe we can start a petition, and you guys can sign this petition about having a central registry so that we can file these things there. So yeah, absolutely, your point is well valid. But also the point you make about the fridge is interesting, because I've heard that a number of times, that when a paramedic goes into a house, the first place that they're trained to go and look is the fridge, because they know that people put healthcare proxies on a fridge or...
Well, we're supposed to put it next to the fridge in the cabinet. So apparently the EMTs here know to look, and Woodland Pond, they know to look for that.
Right, yeah. Very good.
We got some advice about 15 years ago or so from the UFT, which has attorneys that my wife was a retiree of the UFT, United Federation of Teachers. Would you say that that's as good as any other, or because that was included in her benefit plan? Because you pointed to some things, I don't know if they will. We may have to revise it because it was already more than 10 years old.
Right, yeah. I think I might know who you're talking about. There's a firm maybe down, I think, Long Island way. I'd like to say Hopnik, or I can't. There's a... Yeah, terrible pronouncing these things sometimes. Where they work for the union for teachers, and they provide... But they're very basic documents, the ones I've seen, very basic. It's not, from a professional courtesy perspective, it's not one, I can't speak for another, I don't know what was discussed at the time. But the will that I saw a few weeks ago from this firm who represent teachers didn't have a backup beneficiary in place. So it was just one beneficiary, but there was no backup, which to me seemed odd. But I don't know what was discussed, but I found it odd. And it got me thinking about this union and wondering, what went on. So I asked, what went on? And they said, well, they met with me, and it was a 10-minute discussion, and then they just sent the drafts, and then we met them and then signed it, and that was it. There was no real in-depth discussion about needs. But that was what I was told. So it's all hearsay. We all know what hearsay does in court, right? Doesn't work. It's not very good.
I have a question, Anthony. What happens if your healthcare proxy and or your power of attorney become incompetent or die around the same time before you're able to change them? What happens to your wishes, and then what happens to your financial decision?
Sure. Well, if you haven't named a successor, which in this hypothetical, I'm guessing we haven't named a successor, then unfortunately it falls into a guardianship proceeding. So if there is no named backup agent under the power of attorney, then we need to go to court to get a guardian appointed. One thing you should note though with the healthcare aspect is slightly different, because there was a law passed in 2017 which held that there is a priority of people who will be able to make basic healthcare decisions on your behalf without the need for a healthcare proxy to be in place. First is the spouse, second is the children, so on and so forth. So in your hypothetical, whereas with the power of attorney you would need a guardianship, with the healthcare proxy, however, if there is no healthcare proxy, the order of priority would be applicable, although it's healthcare decision making at its most basic. So.
I think my papers need updating probably 5 years ago, and our family attorney has retired, and he's hard to find. He's either on Cape Cod or somewhere else. Do you have availability of doing this for me?
Oh, of course, yes, I do. I mean, I want to make it very clear, I'm not here to get business, I'm actually here to pass some information, but if anybody needs help, I have an office in Kingston, that's my main base. I also have an office, a satellite office in Poughkeepsie, and I have my loyal staff, Judy, Debbie, my wife, Morgan.
If I was to name my children as agents, do they have to be there to sign things, or?
Well, if we're talking about the power of attorney, that depends on what your wishes are. Because if you say to me, I want my children to be the agents, but I don't want to give them authority immediately, then I'm going to say only you need to be present to sign the power of attorney.
Right.
If you say to me,
and I think that sounds like a good way to go, but still.
Yeah, but they don't need to be present because there's nothing in law.
Because they don't live in this area, basically. Okay, and I want to make a comment on the healthcare proxy that I had my wife, but she has since died. But it said is not reasonably able to serve as my healthcare agent by reason of disqualification, unavailability, unwillingness, incompetence, or otherwise. I appoint my daughter, and then it goes through, and if she's not available, whenever I hereby appoint my son.
That's correct.
And that's the way that would be.
That's exactly what we were talking about earlier on. You would name a backup. So in your case, you have your wife, and then your daughter, and then your son.
But the fact that my wife is deceased, does that make this healthcare proxy invalid?
No, because it says, you read it back to me, you said, if my wife is unable to act.
Right, okay. But I still think I need to have all of this gone over, and maybe a power of attorney too.
Well,
I should call your office.
Please do. I have my cards here in case you're interested.
Yeah. And I copied it down from the first slide, but I'll gladly accept your card.
Very good. Sure, you can, yes.
There's another question.
Thank you. Yes.
My question is, I have to redo all these documents since 5 years ago. And I am in search of a power of attorney, a healthcare agent, healthcare proxy. If anyone in this room would like to fill one of these roles for me, I'm inviting you to contact me, and I will do the same for you. Because I have family, and my friends are all busy people. I really don't know if they could do what's needed. So, and certain things like professionals could do some of these things, but that's not the same as a healthcare proxy going in and talking to the doctor.
Right. And that's, yeah, that's another area of concern for a number of clients that I meet who don't have children and they're single, they don't know who to name. And I was talking to one client recently who she was wanting my assistance with her to set up a 501c3 to try to generate an agency that could house and pay potential agents for those who need help. So watch this space, but yeah, you're not alone. You're not alone. It's definitely a widespread concern with a lot of people. But yeah, if anyone's interested, by all means, I mean, you know her better than I do, so by all means, she seems like she's,
How long are you gonna live?
Jeffrey.
Longer than you.
We're here forever, Jeffrey.
Any other questions for Anthony?
One more.
Just
When you answered the question, if the health care proxy dies, at the order, who did you say would be next in order?
It was to the gentleman here where he had, his wife was the healthcare proxy, and then he had his daughter as the backup healthcare proxy, but failing that, his son, as the backup healthcare proxy. Usually it's the daughters that tend to be appointed as the healthcare agents. I'm not sure why that is. Yeah, right. Yeah, they're smart.
I mean, for a healthcare proxy, you want somebody that also knows something about healthcare.
Absolutely.
Not just, I mean, it's a good person and doesn't understand issues of healthcare.
Absolutely.
I mean, one of the issues is particularly if you are in an accident or something and medicine has progressed to an extent that what we thought maybe 15 years ago, it's terminal, may not.
Right.
And so having somebody that a little bit up to date, not necessarily have to be a professional, but at least has some concept.
Yeah, no, absolutely. Someone who has common sense, believe me when I say common sense, is absolutely fundamental. When people say to me, who can I appoint as my agent under a power of attorney, they think that you need a financial advisor or an attorney. You don't. You just need someone who has common sense. And I think the same is applicable here with a healthcare proxy. Someone with common sense, but it would certainly be beneficial if they had medical intelligence as well. But how many of those are out there? That's the problem. Yeah, very few.
Any other questions for Anthony? Well, thank you so much, Anthony.
Thank you so much for your time. I appreciate it. Thank you.
Common sense. It's not very common.
The green dots. Oh, now I know what it is.
Well, not even two, but we have the same attorney, it's the same people that handle, and I did my committees, exactly. They send you the plans, you fill them in, they send you the plans.
This is a T4, right between the lungs. So this line goes in through the back. And it takes up 2 vertebrae to get to the disc. And then it hits up what
You know, I should say this.
both sides of the
I suspect he's probably not. I need this.
He just showed us the pictures.
Looks like they taped that.
They often do take,
Have any favorites here?
There are.
Yes.
Yeah.